aren't the only ones making a profit from the drug business. So are the police. Law enforcement officials have been profiting from the valuables they seize during drug raids. And they are now making a special operation of stereotyping people who travel with courier profiles in order to seize the cash they're carrying. Increasingly, critics say, all of this is to the detriment of innocent citizens. Asset forfeiture is an ancient common law concept. In the U.S. today, it translates into the federal government's ability to seize property gained through profits from illicit drug sales. Police departments spend proceeds from seized goods on salaries, informants, and equipment used to prosecute drug dealers. Many people consider that poetic justice. However, according to a 10-month study by the Pittsburgh Press, 80% of the people who lost property to the federal government were never charged with a crime. Further, critics argue, methods used to seize cash and property, such as courier profiles, are racist.
What is a profile of a drug courier? Generally, they are males of foreign nationality, mainly but not limited to Cubans, Colombians, Puerto Ricans, and Mexicans, or any swarthy, dark-haired outlander.
Enforcement officials assume that because a person of minority status pays cash for something, this makes them a likely candidate to be stopped and searched. This has prompted some to wonder whether asset forfeiture laws will make obsolete such venerable traditions as innocent until proven guilty, probable cause, and all men are created equal. The Fifth Amendment to the Constitution provides that no person shall be deprived of their property without due process of the law. But 1984 amendments to federal racketeering laws give authorities the power to confiscate possessions of suspects who are never charged with or convicted of crimes. Law enforcement officials favor the use of civil forfeiture laws because the burden of proof is much lower. Rather than proving a citizen guilty beyond a reasonable doubt, they need only satisfy a lower burden of proof, a mere preponderance of the evidence. And the burden of proof can be costly for the alleged victim. In order to reclaim property, victims must prove their innocence and pay a courtroom processing fee for the chance to do so. While police departments have netted over $2 billion, the number of wrongfully impoverished victims who lost houses, cars, boats, planes, and thousands of dollars in cash is alarming. And all of that money is not spent on bringing drug war criminals to justice. In fact, some reports claim that police officials have spent seizure proceeds on things like air conditioning and sports cars. For the victims, on the other hand, the seizure laws have been devastating. In Hawaii, an elderly couple lost their house 4 years after their mentally ill son was arrested for growing marijuana plants in their backyard. In Vermont, a woman and her 3 children had to move out of their ranch house into a rented duplex and go on welfare because her husband was arrested in Minnesota on a cocaine possession charge. Examples similar to these are in the hundreds, and the numbers are still growing. Law enforcement agencies making use of forfeiture on a small scale are close-mouthed when it comes to details on allegedly innocent victims. But in general, they say forfeiture laws are effective in catching drug criminals.
Hello, my name is Judy Osburn. I'm author of the book Spectre of Forfeiture, which describes a through-the-looking-glass world of jurisprudence where, incredibly enough, civil asset forfeiture laws allow the government to seize property without charging anyone with a crime, and then keep that property without ever having to even prove a case. U.S. Representative John Conyers, last October, in introducing forfeiture reform legislation, described present forfeiture laws as a law designed to give cops the right to confiscate and keep the luxury possessions of major drug dealers, mostly ensnares the modest homes, cars, and hard-earned cash of ordinary law-abiding people. This was not the way it was supposed to work. Under present forfeiture laws, property is presumed guilty. Under a legal fiction, it is personified and prosecuted as if it were conscious and capable of committing a crime. Therefore, cases have very strange names, often sounding like the United States of America versus a piece of real estate located at, or a sum of cash, or the name of a car. These prosecutions are actually against the property itself, and indeed, Supreme Court bases this prosecution against property on an analogy to a medieval superstition, that of a deodand, which was the tainted object that was the cause of a man's death, such as a runaway ox cart that killed a man was forfeited to the king, and this was irregardless of the guilt or innocence of the owner. All that it takes to forfeit your home, your cash, your car, is probable cause to believe that the property was intended to use in a drug exchange, or was the proceeds of a drug exchange. This is the same standard that is required for a search warrant. Property forfeited is therefore can be forfeited based on mere hearsay and innuendo, even on the testimony of informants who stand to gain up to 25% of the forfeited assets. Yet, even though the government's burden, they need only show probable cause, it is up to the owners to provide admissible evidence proving a negative, proving that their property was not used in a drug crime. Most owners simply lack the money, the financial means to contest forfeitures, especially considering that the burden of proof is on them. For instance, let's take it that you saw an ad for a good car, maybe $4,500 range. So you go to the bank, you withdraw $4,500 in cash because you know that you have better leverage offering a private party cash for their car. Some quirk, you get stopped on the way. Police see your $4,500, not thousand, if I said $4,500, and they say, well, we assume this was intended to purchase drugs. Under the law, that is the presumption. Now you have a chance to rebut that and go to court and say, no, look, I got it, I withdrew it from the bank, etc. But in order to do this, you're going to have to pay an attorney or a retainer of around $10,000. Let's say that you actually go ahead and pay the attorney $10,000 in order to get your $4,500 back. Now you produce your receipts from the bank. I withdrew this. You produce your income tax returns. This is how the money got into the bank in the first place. Yes, it wasn't illegal proceeds, but can you still prove this money wasn't intended to buy drugs? It's kind of hard. Added to that, police get to keep nearly all of forfeiture proceeds. This has led to a rising tide of abuse across the country, and it has been documented by newspaper and TV stories documenting hundreds of cases of innocent victims. As testimony at United States government hearings, these stories seem to point to a pattern and practice of abuse by states and local enforcement that is fostered by a built-in financial incentive that cannot help but impact law enforcement priorities. In other words, priorities are so skewed that 80% of property forfeited to the United States government is seized from owners who were never even charged with a crime. Lien holders, business owners get caught up in a judicial nightmare based upon something that maybe a customer or a tenant did or did not do, for that matter. In fact, if you are a landlord, be aware of contacting police if you suspect a tenant may be dealing drugs, because your report of your suspicions is enough evidence to forfeit your entire apartment building. And whereas your tenant may get off completely of criminal charges because, after all, proof beyond a reasonable doubt is required, you may lose your apartment building based upon your report to the police. This violations of due process, like, for instance, the burden of proof being placed on the defendant. Well, one violation of due process is the basis for further destruction of the Fifth Amendment. Since 1984, even if you are acquitted of the crime upon which the forfeiture is based, the same facts can still be tried again. Because, why? Because at the second trial, though the government was not able to prove a crime committed, perhaps you won't be able to prove that a crime was not committed. And this double bind can get really wild when the government uses combinations of laws and rules governing separate criminal and civil prosecutions for the same crime to deny for instance, as they did 1 year ago, to deny innocent shareholders of a corporation the opportunity to defend their interest in more than $25 million of seized assets. Basically, the government, based on the actions of the vice president, seized the corporation's entire assets. And because of this double bind of two prosecutions happening at once, the shareholders were unable to defend themselves in the criminal case, and therefore did not have the assets, and the civil case was a done deal. Precedents for these outrageous precedents were set in the drug war, but they've created a great foothold for spreading abuse into vast other areas of the laws. Everything from obscenity, immigration. If there's one piece of arguably obscene material in a bookstore, the contents of the entire bookstore may be forfeited. There are forfeiture laws attached to immigration violations, gambling, copyright, archaeological fines, firearm violations. Even a woman's feather artwork was seized in Ann Arbor, Michigan, and forfeited based upon an obscure law because she was using feathers of migratory birds. It was an ancient turn-of-the-century law, but yet they dug this up to seize her $800 artwork. Loan fraud. Any false information given to a FDIC-insured institution in order to obtain a loan may cause the forfeiture of any property that can be traced to that loan application. This is really scary. Right now, as the law stands, the courts say this law can be applied retroactively. In other words, if your grandfather made a misstatement on a loan form, the government could step in and say, the property you inherited from him is now forfeitable because we just discovered that he made that misstatement. You see, the only statute of limitations that can apply only starts the countdown after the government discovers this information. There's no age limit at all to the age of the documents that they can pursue in order to make this discovery. As in all in rem or proceedings against a thing, forfeiture proceeding, property is presumed guilty, and therefore mistakes made on complicated loan forms that may have been submitted many years earlier are presumed to be intentional fraud. Owners must prove the innocence of a statement made on a loan application many years earlier. Another innovative interpretation of forfeiture statutes that the Department of Justice has been pursuing is to pursue the fraudulent billing by physicians, called welfare fraud. Well, a mistake on a form, complicated form, this can taint a physician's entire funds. So you see, it's really going way past any kind of, the drug war has set precedents that will affect everybody and are affecting everybody. Recently, we've had some very favorable Supreme Court decisions in this last year, revolutionary in fact. However, they only touch a small fraction of the constitutional problems that we have with forfeiture laws. And far too many people have already lost and are losing, and these cases take so long to make their way through the courts. And once again, the laws are so unfair that the majority of people never even get to court in the first place. But before I go on and talk a little bit about the recent decisions, I'd like to give you a little history of how these laws came about. They've been described as Kafkaesque. They are so, it's so unbelievable. The first time you hear it, you say, no, she must be wrong. That couldn't be, not in this country. But it's true, and it's been over and over again. Early Americans, our founding fathers did incorporate these in rem proceeding against a thing forfeiture procedures into admiralty and maritime law that was used to seize enemy ships at sea. Fictitious personalities were assigned to these ships, and that way it made the legislation easier, and it avoided the use of having to travel overseas to sue the Queen for her ship. Americans adopted these from ancient Anglo-Saxon laws, I say, based upon medieval superstition. In fact, the English definition of felony is an offense which occasions the total forfeiture of either the lands or the goods or both. And these were much hated by our founding fathers. The mid-17th century English Navigation Acts, in effect, made smugglers out of most of our founding fathers. And enforcement of these navigation acts through non-jury vice admiralty courts was bitterly criticized by John Adams and other Americans and was complained of in the Declaration of Independence. Our founding fathers therefore put in Article 1 of the Constitution forbids bills of attainder. This is the ancient English forfeiture consequent to conviction. And the Constitution also prohibits the punishment of treason for corruption of blood and forfeiture of estate during the life of the attainted. Even our first Congress passed a law that said no conviction or judgment shall work corruption of blood or forfeiture of estate. No forfeitures. This law is actually still in existence and as a USC title. The early American statutes incorporated these in rem procedures to enforce customs duties. You have to provide proof that you've paid your taxes when you're entering goods into the country. But the Supreme Court at the time, in the early days of the nation, declared that when forfeiture is founded upon the personal guilt of an individual, in other words, if it's punishment, then it is unconstitutional unless, of course, it is part of the whole criminal due process justice procedure. It wasn't until the Civil War that a total revolution in this criminal jurisprudence took place. The passage of the 1860 Confiscation Act, 62, I believe, Confiscation Act, which declared the property that belonged of Confederate officers or those who aided and abetted Confederate soldiers would be subject to forfeiture through these in rem proceedings. And senators who were opposed predicted that this would be used for tyranny and a whole revolution in our criminal jurisprudence. But the Supreme Court said it's okay as long as it's applied only to enemies. Well, it became kind of a backwater area of law, but sure enough, just as predicted, it was used to bypass the Constitution in years to come. First, during alcohol prohibition. You could have your car seized if you gave a hitchhiker a ride and he had a flask of liquor in his pocket. It doesn't matter that you were innocent, didn't know, it was the car that was guilty. And then, of course, back into the drug war. The worst precedent we've had in this drug war happened in 1974. It was called Calero Toledo versus Pearson Yacht Leasing Company. This is where the Supreme Court declared that due to the government's compelling interest in the war on drugs, that it is constitutionally permissible to forfeit property from completely innocent and non-negligent owners. The case at hand, some people had leased a yacht from Pearson Yacht Leasing Company, and they had one marijuana joint on board. The boat was confiscated in Puerto Rico and was forfeited from the leasing company with the approval of the Supreme Court. Well, this horrendous precedent has been used by the government time and again. Hey, if we can forfeit property from completely innocent people, then whatever constitutional issue you have in mind couldn't possibly apply, especially if somebody's actually violated the law, even if it was a minor infraction. This happened repeatedly over and over again. District courts, appellate courts. Some appellate courts would decry the draconian results of forfeiture laws, but not if it meant they had to give the property back. They would do that in a form they called indicta. This is opinion. This is really horrible, but as long as we can forfeit the property, we can say that this is kind of unconstitutional. But the precedents were just bad and worse, snowballing, until 1993 was a banner year for forfeiture decisions in the Supreme Court. Beginning in December 92, U.S. versus Republic National Bank, the government argued that you couldn't appeal the forfeiture of property because it had already deposited the money in the Treasury, and therefore, although if a jury awarded property to the claimant, the owner, the government could appeal and not give the property back. If the jury awarded property or the court awarded property to the government, well then the owner cannot appeal that case because it's no longer under jurisdiction. Well, the Supreme Court couldn't really back that argument, so we won that one. Another one that was pretty sure that they were going to have a hard time backing the government's argument was in February 93, United States versus property located on Buena Vista Avenue. We call it Buena Vista. Here the government argued that the relation back doctrine, now this is an ancient doctrine that says, and it is written in statute, that property becomes entitled to the United States government at the moment of the offense. Therefore, anybody who buys it subsequently is subjugated to the government's prior lien. In other words, if person number 2 used their house to store drugs, then the 10th person who bought that house doesn't really have a right to buy the house because that second person used the house in an illegal manner. So once again, the government wanted to use this relationship back doctrine to deprive innocent persons of the right to raise their innocent owner defense, even though Congress in the drug laws has put in that, okay, you can't forfeit property from innocent people. Unfortunately, that's not true of many, many non-drug related forfeitures. And then the real revolutionary decision became in June '93, Austin versus the United States, where the Supreme Court finally recognized that indeed forfeiture is punishment and limited by the Constitution. The government had been claiming all along, very successfully, that not only is forfeiture not really punishment, it's remedial nature. It's just making the government whole for its expenses in fighting the war on drugs. Well, the Supreme Court declined to rule on the government's claim that the innocence of the owner is actually totally irrelevant. But it did question the idea of the legal fiction. In fact, the majority would limit the value of the property in relation to the offense. However, the minority opinion, they still cling to the legal fiction that property is guilty regardless of innocence or guilt of the owner. And they would say, yes, it violates the excessive fine clause, but only if there's not a substantial connection or a close relationship between the crime and the property used. Fortunately, however, law is governed today by the majority opinion. Property must not be forfeited that is disproportionate value to that. However, unfortunately, the government appealed that, and so we still don't have any definitions. The most recent is Daniel Good property in '93, which declared that it is due process violation in December '93, a due process violation to seize real estate before a trial, before an adversary hearing. Now, this isn't going to affect the final outcome of many, many forfeiture cases. However, it has produced the most immediate results in that many homes are now being returned. We have a desperate need for statutory change. There are so many things wrong with these laws. We do have 2 bills in committee right now. The most comprehensive reform is John Conyers' Asset Forfeiture Justice Act. This is H.R. 3347. This comprehensive reform bill will require the government to prove its case by clear and convincing evidence. It will establish the right to a trial by jury with assistance of counsel in all forfeiture cases. It will limit excessive forfeitures for minor crimes, and it will actually require conviction of the owner for the crime upon which the forfeiture is based. Possibly just as importantly, too, is H.R. 3347 will also eliminate the fiscal incentives that corrupt law enforcement priorities. Yet it will still allow police to be funded by forfeiture proceeds, in that it will deposit forfeiture proceeds into state treasuries to be distributed according to state law, rather than the commission or bounty hunter basis we have now, which has been compared to the Sheriff of Nottingham syndrome, where the evil sheriff funds his coffers through dispossessing the poor and the helpless who cannot fight their cases in court. As I said, the recent Supreme Court decisions address only a tiny portion of the constitutional violations. These decisions emphasize the urgent need for statutory reform. This is where an organization, FEAR, comes in. Forfeiture Endangers American Rights. We have defeated California attempts to expand forfeiture laws, and in fact have caused the previous California laws to sunset. And we are back under still a problem of a law, but much better than it was before. As I say, the 2 bills, we have the ball rolling, but we need support. We are very few, we are very new, And we are facing lobbying efforts from those feeding at the forfeiture trough on our tax-supported time. For instance, little antidote, after the tragic slaying of Donald Scott, the district attorney in my county blamed the lure of forfeiture revenue for Donald Scott's deaths, for the fact that officers lied to get an affidavit for a search warrant, which eventually became Donald Scott's death warrant. When he was, I went, well, maybe we can get some help from him. I went to interview him. He was up in Sacramento lobbying for state forfeiture laws, which would make it even easier for police to acquire forfeited assets. Please, we need your support. We need you to write both your U.S. representative and both your senators and ask them to sponsor companion legislation. Ask your your House representative to co-sponsor the Asset Forfeiture Reform Act, H.R. 3347. And please help us. Thank you.